All right, folks, today we are going to talk about lawsuits versus workers' comp claims. What's the difference? Welcome to yet another informative segment of Tuesdays with Mitch. I'm your host, Mel McCoy, for Tuesdays with Mitch, and we are here for all of your Tuesday sit-downs with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experiences to answer your questions or any fun topics that might be useful in the personal injury world. Welcome again, Mitch. How are you doing?
I'm well, Mel. It's great to be with you again.
It is. I was about to ask you how's the weather out there, but I have a feeling it's the same where I am.
Well, you know something. The truth is, I really do enjoy it. I enjoy spending the time with you, but also more importantly, giving information to the people that might be wondering what their rights are after an injury claim, and just to be informed in general. So let's talk a little bit about today's topic.
Let's do it. I mean, I know usually in your past segments, you kind of like to either describe more or summarize the topic we're actually discussing today. Would you care to do that for this? The lawsuits versus workers' comp claims. What's the difference? I mean, I guess a general sentence.
There's a difference?
Or is there? You tell me.
Yeah. So it's actually a tremendous difference between a lawsuit and a workers' comp claim. So let me start off with what defines a workers' comp claim. Every state has their own workers' compensation laws, and they're different whether you're in Texas or New York or Connecticut or any state in the union. So first of all, what defines a workers' comp case is workers' comp claims typically arise when somebody sustains injuries while they're working. Now, people often ask, well, what about if I'm on my way to work? Probably not a workers' comp claim. What about if I'm on my way home? Probably not a workers' comp claim. What about if in my company's parking lot? Maybe. It depends. But if you're working and you sustain injury, typically workers' comp has specific laws that prevent you from bringing a lawsuit against your employer for any actions where you sustained injury due to the fault of your employer or from coworkers. But you are entitled to, even if you're 100% at fault for your injuries, entitled to be compensated for your loss of earnings and your medical bills. 100% of your medical bills. In New York, you get 2/3 of your lost earnings before taxes multiplied by the percentage that you're disabled. So for example, let's suppose you make $3,000 a week. 2/3 of 3,000 is 2,000. So they look at the 52 weeks before the injury was sustained, and they average those earnings for those 52 weeks. If you haven't been working 52 weeks, or you start a new job, you're still entitled to workers' comp, but they look at less data to come up with your weekly wage. But if you've been there for more than a year, they'll look at the last 52 weeks. They'll average that. So if you just got a raise, you might not get that entire new amount that you're earning. They look at 52 weeks and they average that and they say that's your weekly wage. And they take 2/3 of that before any taxes are taken out. And that's what you're entitled to get. You have to be disabled for at least a week. You have to report the claim within 30 days to your employer. Your employer has 14 days to report it to his insurance carrier. And then within 18 days, you're supposed to start receiving your checks. And that's for 2/3 if you're 100% disabled. Now, let's suppose you're not 100% disabled. Your accident happened a year ago, and maybe you're 50% disabled. That's in accordance with the doctors that examined you from the insurance company or a judge's decision. Well, then 50%. Now all of a sudden you're not getting $2,000 a month anymore. You're only getting $1,000 a month. And maybe your doctors say you're 50% disabled. The insurance company's doctors say you're 0 disabled. You're fully ready to go back to work. And the judge looks at it and says, okay, let's call him 30% disabled. So you're still getting almost a third. But it depends on what the judges say. Workers' comp doesn't matter who's at fault. For a lawsuit, first of all, you have to show somebody's at fault. You don't have to show anybody's at fault for a workers' comp claim. You just have to show you were working when your accident happened. For a lawsuit, you need to show the defendant is at fault.
So actually, a quick question. So I can file both a lawsuit and a workers' comp claim for the same accident?
Oftentimes you can. So for example, let's suppose you're driving a truck. Okay. And somebody is driving a car and they blow a stop sign and they smash into your cab and you go off the road and you sustain injuries. Well, you can bring a workers' comp claim under your employer's workers' comp insurance, or if you're self-employed, if you purchased your own workers' comp insurance, you could bring a comp claim. Additionally, if it's in New York, you could bring a claim under no fault through the insurance of your vehicle. No fault pays 80% of your lost wages up to $2,000 a month. Workers' comp pays 2/3 of your lost wages. 80% is more than 2/3, but it's got a limit at $2,000 a month, whereas comp doesn't have that limit. So you can bring those two claims, but also you could bring a lawsuit against that car that ran the stop sign. In addition, now, no fault will pay your medical bills up to $50,000. Comp doesn't have that cap. Comp could go on for years and can pay 500,000 medical bills, whatever it is. And in addition, you could bring a lawsuit against the driver of the car. Now you have to prove the driver of the car was at fault. For your comp claim to get your bills paid and your lost earnings, you don't have to prove it. You could be at fault. You could be the one that ran the stop sign. Doesn't matter. There could be no other vehicle for a comp claim. But you can have a claim against that car. The difference is for the claim against the car, you can also claim for pain and suffering, including the loss of quality of life. So whereas a comp case only looks at your lost earnings and your medical bills, a lawsuit looks at your pain and suffering, which is why if you hear somebody got a multi-million-dollar award, that's typically from a lawsuit, not from a comp case. Comp cases, you're never going to hear about somebody getting $1 million. But third-party lawsuits, those types of claims are frequently occurring more and more. So it depends on the specific facts to determine whether or not you have a lawsuit, whether you have a comp claim, or both.
Could you I think this kind of ties into the next question, or maybe you might have already mentioned it. And if I missed that, I apologize. But which type of claim usually provides more compensation for the victim?
Okay, so initially, a comp claim will provide more compensation. Initially, immediately, because with a comp claim, you don't need to establish fault. You don't need to establish the full extent of your injuries. It just has to be that you sustained an injury that keeps you from working for at least a week. So you can establish a comp claim right away. If your employer verifies you got hurt at work, and these are your wages, that's all it takes. Your comp claim could be established and you can start getting money right away and your medical bills right away. Now, your employer can contest the claim. That's called a controverted claim. And controverted claims can take a longer time to establish. Why could a case be controverted? Your employer could say, he wasn't working for me, he was working for somebody else. And you were paid off the books, and it's hard to prove. Your employer maybe didn't pay for workers' comp insurance. And if you're being paid in cash, that likelihood increases. Now, all of a sudden, your employer says he wasn't working for me, he was an independent contractor, and can controvert the claim. Now, you could still establish your claim, even if your employer doesn't have insurance and says you aren't working there. A judge might believe your claim that you are working, you sustained injury. And if there's not insurance, he might look, if you're working for a sub, he might look to the GC or coverage. Or if there's no coverage whatsoever, there's a state insurance fund where the state of New York actually provides funds for claims. So your claim might be established even though it's controverted, but it could take more time. But initially, assuming you were working, your employer doesn't deny you're working, you got hurt at work, you go to the doctor right away. If you don't go to the doctor, you can't establish you were injured. You can't say, oh, but I'm in tremendous pain, I can't work. It's not like when you have a cold and you call up your boss and say, I can't come in today, I feel terrible, I'm lightheaded, I got a fever. No, you need a doctor. So, but if you got a doctor, you went to the doctor and the doctor fills out a form called a C4 and you establish your claim and you fill out a form called a C3, you can establish your claim and start getting paid immediately. Lost wages. Whereas for a lawsuit, typically it takes more time to establish the case. You got to prove fault. And the defendant, if they have insurance, the insurance company is going to assign an attorney, investigator, and they might not make payment right away. And it could take years. But ultimately, a lawsuit typically pays more than workers' comp.
Now before we go on to the other final two questions I have for you, I mean, something just lit up with me in terms of what you were mentioning with this. Like, how important is it? Like, let's just say you do get injured. Is it really? It's really important to get that documented. Documentation, is that really going to be key for getting the whole process started?
Documentation is only important if you want money. If you want to go home and just tell your husband or your wife, oh, I feel terrible, and you don't care about getting paid, no, you don't need documentation. But if you're looking to get paid for the losses you've sustained, and our system of justice allows for that. If somebody hurts you, our system of justice isn't that you get to go to them and hit them over the head with a shovel. That's not what happens. If somebody hurt you and you sustained injury, they can't make you well. Your doctors, you have to rely on to get you as well as possible. But in order to get payment, you need to show proof. For an injury claim, that comes by way of doctor's records. Whenever you see a doctor, doctors, they want to get paid.
So and I'm sorry to interrupt you. So you're saying as soon as the injury happens, you should seek some sort of medical advice?
Well, that you should do for your health.
Right. Okay.
That for your health, that's the most important thing, because whatever money you get from a case, is secondary in importance. Your health is much more important than any money you get from a case. And if you think money's more important than your health, then you should see a psychiatrist as well. But in order to get money for your claim, you need to have medical records. And the sooner you get those records, the more likely you are to get compensation, because the insurance carriers routinely say, well, if he was so badly hurt, why didn't he go to a doctor? And if he hurt his neck in this accident, why did he wait a month to go to the doctor? Or why did he wait 4 days to go to a doctor, or even 3 days? Oh, maybe he only went to a doctor after he saw a lawyer. So he's not really hurt. He's just trying to get money from my client for an opportune time. No, the sooner you get medical help, the better off you are for your health and for presenting your claim. That's important, because without proof, you're not going to get anything. Number one, you're going to try and get the care that you need. Number two, you'll get more money typically by establishing your injury with proof. Doctors want to get paid, and in order for doctors to get paid, they got to, by law, have digital medical records. Federal law requires it's all digital now. The handwriting, doctor's notes, that's over. They have to be digital now. And doctors, in order to get paid, they have to establish that there's treatment. And those records that they use for their billing and to document your treatment under federal law, your lawyer can use that to get you money for your injuries. And even if the doctors are working for a hospital that's a charity, or a clinic that's a charity, they don't care about money, they're still required to keep records. No doctor says, oh, now that I'm here, I'll just keep it all in my head. It doesn't work like that. They're not doing their job. They have to, and any time they render care, they have to keep records. And those are the records that are used to establish your claim and to get you payment. But most importantly, hopefully they can give you some sort of therapy, some medicine, some sort of treatment that'll make you feel better, that'll improve your health in the long term, that'll give you a better quality of life, which is more important than any money you get from a claim. But those records that are generated from that care, and the reason it's called care is because it's supposed to be treatment because they care for you. And if the doctor takes you into their practice as a patient and they give you that care, those records can establish your case, whether it's a workers' comp claim or a third-party lawsuit.
No, that's great. Thank you so much. I know I went a bit off script with that question, but I appreciate you answering that. Now let's go on to the final two questions. How do the processes and timelines differ between these two types of cases?
Okay, so with a workers' comp claim, you have strict timelines, and if you don't meet the timelines, your case might be defeated. For a lawsuit, there's also strict timelines, statutes of limitations, and if those timelines are not kept, your case might be defeated. So in workers' comp, real quick, you have to report the incident to your employer that you sustained injury within 30 days. Within 30 days, you have to report that incident or occurrence. Now, there are exceptions. For example, occupational disease like asbestos, where you can get your lungs injured with mesothelioma, and you might not know when it happened. So there are exceptions, but typically with a traumatic event like a fall off a ladder, you're working in a premises, you're working in a building and a ceiling collapses, or you fall off a ladder while you're climbing up, or the scaffolding fails, or whatever. You have to report the injury within 30 days to your employer. Now, if you hire a law firm like my firm, we can help you with that, but it's got to be reported. That's number one. Number two, you have other timelines. Typically, doctors have to fill out a C4 and establish your injury, and then might need to reestablish your injury at least once every 45 days in order to continue your benefits. If you don't seek medical care, you're not going to establish your case. Your employer has to report the incident, The carrier has to notify you of your rights, all within timelines, 14 days and 18 days respectively. And then payment's supposed to start. Those are all strict timelines. For a third-party lawsuit, you need to file suit within 3 years in New York for most injury cases. But sometimes that's shortened. For example, if the case involves a municipality like a city or a county or the state, you have 90 days to file a notice of claim. If you don't file that notice of claim, under certain circumstances, your attorney might be able to file a motion to file a late notice of claim, but your case could be defeated just by missing that 90-day period. Over, and you're never going to get compensation. So you got 90 days to start your claim with a notice of claim. Then you have to file a suit within a year and 90 days. And if your lawyer doesn't file a suit, it's over. And sometimes lawyers might not realize the building's owned by the city and might blow that statute. And then your case can be over. So hiring a competent attorney is important as well. 90 to 190 days against a municipal defendant, 3 years against a non-municipal defendant. But it's a different time. You have 2 years to start a workers' comp claim, but you got to notify your employer within 30 days. For motor vehicle accidents in New York, to get your medical bill paid and your lost earnings paid under no fault, which is no fault's a common name, but it's 5102 of the state insurance code as enacted in 1978. You got to file your bills with the no fault carrier within 30 days. Otherwise, they're not paying them. They'll deny it. And you could proceed to arbitration to contest the denial. But if they could establish it wasn't submitted in a timely fashion, they don't have to pay the bills. And then that comes out of your pocket. So there are strict timelines, and they're different for a workers' comp case and a third-party lawsuit. And the best thing to do is to hire a competent attorney as soon as possible, and they can help you meet these deadlines. And if you want to consult with us, it's always free and confidential. And you can call us at 1-800-321-1234.
That's we're gonna build a hit record from that song you just sang right there. Now, Mitch, we do have one more. I have one more question. If you can expand on this a bit more before we finish up for today. And what type of accidents can I file both a lawsuit and a workers' compensation claim? Do you have any recent settlements or verdicts related to cases like these?
Yeah, I just had one where it was a case where a client of mine fell off the roof of a building, and he was doing work on a house out in Suffolk County, and we alleged that the owner of the property under the labor law, which was the developer, didn't have adequate height-related risk safeguards in place, and he fell off, sustaining injuries. He had a workers' comp claim immediately against the comp claim isn't brought against the defendant. It's brought against the insurance carrier of his employer. So his employer had insurance, so he had a workers' comp case, paid his lost earnings, and paid his medical bills. And then in addition, we had a third-party lawsuit against the GC and the owner of the house that was being built, which was a developer. And after getting his medical bills paid, his loss of earnings paid by the comp carrier, we settled with the developer and the GC for $3.5 million. He couldn't get $3.5 million on the workers' comp claim. The workers' comp claim paid out a little bit over $200,000, and I think it was $242,000 in benefits. That's what his medical bills and lost earnings were while the claim was proceeding. So $242,000 was the total workers' comp claim, but he got 3.5 million for the third-party lawsuit. So typically third-party lawsuits are worth a lot more. And that was just a recent settlement that naturally he's happy and not about it having the claim in the first place. Nobody's wishes injury. He was scary. He got taken away in a backboard by ambulance, and nobody knew what injuries he sustained. He got taken to a Stony Brook Hospital, which is a level 1 treatment center out in Long Island. And it was scary for him and his family and everything else. But now, fortunately, he's taken care of, and his children will be taken care of, and maybe his grandchildren, if the money's wisely invested. But he's got money. He's got generational wealth now from his lawsuit, and for trusting us with it.
Amazing. Yeah, I think we can sometimes forget that. You sometimes think about the moment, and sometimes it's when you're in that moment, you sometimes forget about the future and those who are actually affected around you. Mitch, thank you again, man. You always open my eyes every time we talk. And as I say at the end of any of these talks, do you have anything else you would like to add on?
Yeah, well, you made a good point. In the moment, your health is the most important thing.
Yeah.
When somebody gets seriously injured, getting them the right care is the most important thing. Nobody, if you got a family members, if you sustain a serious injury and your family members are thinking, how much money are we going to make about this? Rather than, I hope they're okay and what's their life going to be like, something's wrong. Your loved one should be worried about your health, and you should be worried about your health and well-being. But beyond those immediate concerns about your health, you should have the right attorney and somebody that's going to look after your future economically. And that's something that I've dedicated my career to. I spend more time here working than I do with my family, although my family is much more important than my work, of course. But I spend more time here, and I find it gratifying that I take care of my clients' families and their economic well-being, and provide them that type of assurance that I'm going to do my best for them and get them the full recovery that they're entitled to. And part of it lately is in caring for the community, is presenting information to the people, because I think it is important that you get the right advice and you know your rights under the law. And that's something that I'm going to be committed to trying to do more often as well. And I thank you for being a part of the project, Mel. It's good to have you with me. Thank you.
It's definitely good to be here. And, I just want to add on, I said it last week too, what you get with Mitch, even on this podcast or on these videos, he is the same person that you hear, that you see. And he is very, very real, if I could, end it with that note. So, well, there you have it again. Once we have another Tuesdays with Mitch. And I'm going to wrap it up now. I mean, I might do the 1-800 number, but Mitch has already taken care of that. But I'll add it in. But as a reminder, please, if you're listening, don't forget to listen to our podcast. And if you are on social media and watching this on YouTube, don't forget to subscribe, like, share, all that fun stuff. Check out our other social media accounts, and please do follow. The number was already said. I'm not going to sing any songs, but I'll just repeat it right here. Don't forget to call us if you have any, if you want a consultation that's free and confidential, please feel free to call us at 1-800-321-1234. Mitch did it better than me. So just, that's all you can remember. And we'll close it off. I'll say it like I've said last time. I know I learned a lot, and I hope you did too. Thank you again, Mitch. We really do appreciate your time. And I guess we'll see you in the next one.
Thank you. Thank you. It's great.
Of course.
Bye-bye.
We'll see you.
My name is Robert Keller. I was hurt on a construction accident in 2016. I needed a lawyer. It was recommended to me to hire Proner & Proner. I am absolutely just glad I made that decision. Proner & Proner kept me involved. Proner & Proner kept me in the loop on everything that was going on my case. They called to see how I was doing when the case kind of stalled. Anytime I had a question, someone would get back to me, whether it be through email or they would call me personally. Having seen Mitch in the courtroom, he is a razor-sharp litigator. I mean, they tried to lie their way through it, and he would just attack them, and he would just make them look absolutely silly. And the experts that he puts on your behalf are better than anybody else that any defense attorney can put out. My recommendation is if you have a lawsuit or litigation, Proner and Proner should be your first choice. Mitch is absolutely fantastic.